Good morning. That was it?
That's it.
All right. Oh, at least I was prepared for that. Good morning. I let the record reflect state's attorneys present, defendant, and defense counsel are present. Anything we need to take up before we bring the jury in?
Nothing to say. Nothing for them to finish.
So I know the pathologist will be, have to come after lunch this morning, just for me to have an idea how many, what do we have this morning?
2 witnesses this morning. We have the detective and we have Hunter Jones from the company.
Okay. All right. We'll get done, and then doctor this afternoon, and
That should be our last witness and we should rest.
we'll, I'm gonna go ahead and make some of those adjustments on the charge that I sent you guys that I know don't apply. And then, we'll talk about that maybe this morning after we have to rest early, or recess early, and wait for the doctor. We can work on that charge a little bit. All right, you can bring the jury in. Uh-huh.
Yep.
Good morning. Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. Mr. Smith, you may call your next witness.
State calls the Detective Saeed Sarant.
Good morning, sir. If you please raise your right hand, do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can have a seat.
Good morning. Would you state your name for the jury and spell it for the court, please?
Yeah, you can just, you can pull it on down. It should be ready to go.
All right, my name is Saeed Sarant. That's S-A-E-E-D, S-E-R-R-A-N-T.
And how are you currently employed?
I'm employed with the Beaumont Police Department as a persons detective.
How long have you been so employed?
I've been with the department for 13 years and a detective for 3.
Are you a certified peace officer in this state?
Yes,
And what training have you received to become a peace officer?
I completed an accredited regional police academy at LIT.
So what are your duties as a detective with persons at Beaumont PD?
We have to, we investigate crimes and interview suspects, witnesses, all involved.
Okay, and what is persons?
So it's all crimes against persons. They can range from something as simple as telephone harassment, simple assaults, robberies, aggravated robberies, all the way up to homicide.
Now, were you assigned as the detective to investigate the aggravated robbery and murders that occurred at 1830 Elgin on April 10th, 2023?
Yes,
When did you first become aware of that particular incident?
I believe it was that morning. It was probably about an hour or so after the initial responding officers that got into the scene and secured the scene.
Okay. Did you go out to that scene?
I did.
Okay. What did you observe when you got there? Can you describe that for the jury?
Yes. When I first got there, the scene was secured with a crime scene tape, patrol units to block off the street, and several patrol officers. To my knowledge, whenever I first got in there, there was one victim who had not been identified yet, who had been taken to the hospital. And there was the second victim was actually still inside of the, well, yes, he was inside of the residence. Had been, sorry. I'll refer back to my report, please.
Of course.
Sure.
Okay, so the second victim was actually had been brought from inside of the house and was found located outside.
And that turned out to be Ahmaud Hayden, the actual person who was staying at that place.
Yes.
All right, and just if you can look on your monitor there, I'll show you State's Exhibit number 3, which just shows an overhead view from Google Earth of that location.
Yes, sir. That is the location I responded to.
So that house has the driveway that runs along the right side there.
Yes.
The person, the other decedent, the one who died at the hospital, did it take a while to track down who that was, the identity of that person?
Yes, it was. Our ID technicians had to roll his fingerprints because he didn't have any identification on him. To roll his fingerprints and enter them into APHIS. And then once it was entered, some time later, that's when his identity was confirmed.
What is APHIS for the jury?
I don't know what the actual acronym is, but it's basically a system used to identify persons based on their fingerprints, if their fingerprints have already been put into the database.
So it's a huge database that if you rolled my thumbprint, you could run it through there to see if I had my identity, my fingerprints in that database.
Yes.
And if I had been fingerprinted in some official capacity, it would be entered into that database.
Yes.
So that's how you were able to obtain or determine who he was. But that wasn't even until after the autopsies had completed. Is that correct?
Correct.
Now, what do you do as an investigator when you get a case like this? What did you do?
So initially, of course, I walked through the scene, talked to the responding officers, found out if there were any witnesses that were present during the scene, and found out that they weren't on scene when I arrived. They had already been transported to the police station.
Okay. Those would have been Melissa Jordan, Ray Mason, Carlton Ray Mason, and Robin Buckaloo.
Yes,
Did you have an opportunity to interview them?
I did.
Okay. And what were you were you able to understand what had happened that night that caused all of this?
Yes, sir.
What did you do after that?
After completing interviews, with them, I believe the next day we had obtained a Crime Stoppers tip in reference to surveillance footage from a residence on Elgin Street. Made contact with the homeowners there, spoke with them, and they were able to pull up their footage from the night of the incident.
Okay. So the surveillance video was from a house on LG. Was it
1785.
1785? Was that the Dominguez?
I believe it's.
Okay. And were you able to get a copy of that the surveillance, their cameras out front of their house, get a copy of what happened in front of their cameras?
Yes.
And I'll show what's been marked as State's Exhibit number 9. Does this contain a true and correct copy of the surveillance videos from 1785 LG?
Yes.
We'd offer State's Exhibit number 9 into evidence.
Judge, the defense has previously been provided a copy. We have no objection.
Thank you, it's admitted.
And permission to publish.
Yes, sir.
Judge, I apologize. I entered the wrong jump drive in. This is not what I purported it to be. This was we'll get to this one shortly. This is the
Okay.
correct, it'd be State's Exhibit number 10. So we withdraw number 9 at this point, not for State's 10.
Is it, can you get that identified properly with the detective?
Okay. The surveillance video from 1785 LG Street is actually contained, I pulled the wrong jump drive. We've got a couple we're going to go through, but this State's Exhibit number 10 is the one that contains those surveillance videos, correct?
Yes, sir.
This number offer State's Exhibit number 10.
No objection, Your Honor.
So states 9 is withdrawn, states 10 is admitted without objection.
Okay, now, can you orient the jury as to where this house is in relation to the house where the actual murders occurred?
Yes, so,
There's a
There's a lake.
pointer right there if you want
Right here,
to,
you have to turn around and do them.
oh, okay.
or you could do it on this one over here. They can all see whichever one's more convenient.
So, this house is actually located southeast of, the house where the, robbery homicide occurred, and, believe the 1830 LG is going to be on the northwest side of LG Street, about I think it's the fourth house from this corner on the right side.
Okay, so that house is further down, it's not visible on this particular surveillance video.
Right.
And we just saw a car, a Suburban, that just turned from LG onto Avenue E.
Yes, sir.
Okay. Now, were you able to determine the date and time that this is all transpiring? Is that accurate on the
Yes, sir.
right
It is.
corner, right bottom corner?
Yes, sir. It is accurate.
So this was April 9th, 2023 at 23:12:18, which would make it 24-hour time. That would make it 11:12:18.
Yes, PM. Yes, sir.
Was that gold-colored Suburban, did that turn out to be important in this case?
Yes, sir. That Suburban belonged to Carlton Mason.
And so they left that house, well, did you speak with Carlton Mason
Yes, sir.
about what had happened, what had transpired?
Yes, sir.
And so did his story match up with the surveillance video?
Yes, sir.
That they left about 11:18 and then came back at some point after that?
Yes, sir.
So that would have been the same Suburban returning to the home at 11:41
Yes, sir.
PM? So what was significant about this?
So in this video, the Suburban is returning back to the residence, and probably less than a minute after the white Expedition goes by, traveling west on LG towards the dead end.
Okay, so less than a minute after the Suburban has come back, that Expedition came from a different direction,
Yes, sir.
but went straight on LG past the turn on Avenue E.
Yes, sir.
And again, there are only 4 houses on that dead end of LG.
Yes, sir.
And then the road stops and the railroad tracks are there.
Yes, sir.
So even though there are only 4 houses on that part of LG, it still took that Expedition about 45 seconds or more to turn around and come back out.
Yes, sir.
Did that turn out to be significant?
Yes, sir.
Now, this video purports to be April 10th at 2:16 in the morning.
Yes,
So does that turn out to be significant?
yes, sir.
And so at 2:21, Beaumont Police first arrived at that location.
Yes, sir.
So this is really 3 or 4 minutes after we see that expedition go by. How does that turn out to be significant?
So, the expedition that comes by, prior to this is the same expedition that went by, earlier in the before the midnight hour. It was determined that the vehicle, we found belonged to, Shirley Jackson. And in speaking with her, she, stated that, whenever we.
Object to hearsay.
She's already testified to this, Judge, I would think it, at this point. I can rephrase.
Okay.
When you spoke to Shirley Jackson, the things that she told you, were they corroborated by physical evidence and by video evidence?
Yes, sir.
Okay. And, the fact that that vehicle was in the neighborhood at 11:40, whatever, and still there, or again there at 2:20 in the morning, did her story, or the version that she told you, did you find it to be truthful?
Yes, sir.
Did you?
Judge, object to that. That's invading the purview of the juror whether a witness is truthful or not.
I said, did he feel that it was truthful?
Overruled.
So you felt like she was forthcoming and honest with you?
Yes, sir.
Now, at first, her story wasn't truthful. Is that true?
Yes, sir.
But how long was it before she came to you with the truth?
It was the following day.
Did she detail to you who was with her
Yes, she did.
in that vehicle?
Yes, sir.
Was it more than one?
Yes, it was.
Was it 3?
It's 3 people. Yes, sir.
Did she detail to you when and where they exited her vehicle?
Yes, sir.
Was it close to this location?
Yes, sir, it was.
But it wasn't on LG Street.
No, it was.
Did she detail to you what she did after these individuals exited her vehicle?
Yes, she did.
What was her relationship to the people in the vehicle?
She was the girlfriend and child's mother of Paul Westbrook.
And Paul Westbrooks was was he related to anybody else in the vehicle?
Yes, sir. He was related to Robin Dotson, who's his cousin.
And Robin Dotson died in that house.
Yes, sir.
Did, so did she relate to you that they were with her and got out of her vehicle?
Yes, sir.
And then did she tell you where she went after they got out of her vehicle?
Yes, sir, she did.
Okay. Were you able to corroborate that in any way?
Yes, sir, I did.
How?
I was able to obtain surveillance footage from one of the locations that she went to.
Where was that?
That was Buzz's 1405 Washington.
Okay. And did she detail about what time the individuals got out of her vehicle?
Yes, sir.
And about what time she went to Fuzzy's?
Yes, sir.
And about what time she picked them up?
Yes, sir.
Did all that relate? And you were able to go to Fuzzy's and look at their surveillance video?
Yes, sir.
Were you able to determine if she was in fact being truthful by finding her on that surveillance video?
Yes, sir.
Show what's been marked State's Exhibit number 9. Is this the surveillance video from Fuzzy's?
Yes, sir.
Where is Fuzzy's?
As far as
Actual location.
14, it's on 1405 Washington Boulevard.
So it's like Washington Avenue 8.
Yes, sir.
Now we'd offer State's Exhibit number 9, surveillance video of Fuzzy's.
We've been given a copy, Your Honor. No objection.
9 submitted.
So that shows to be April 10th, 2023, about 1:15 in the morning is when she shows up at Fuzzy's, which is about an hour before.
Mr. Smith, can you turn it down or?
So about an hour before she's seen on LG Street again.
Yes, sir.
Now, what else did Shirley Jackson, what else did she give you? As far as evidence in the case, or the location of evidence in the case?
She had provided us with the location of where the firearms were. The firearms that were used at the scene. She provided us the location of where she told us she had put the magazines in one location and the firearms in another location.
Okay. Did you go to those locations?
Yes, sir, I did.
Were you able to find the magazines?
I was not.
Were you able to find the guns?
Yes, sir.
Where did Shirley Jackson live?
She lived at 5080 LD, Plymouth Village Apartments.
And did she dispose of those at those apartments?
No, sir. It was said to me that she had disposed the magazines at 125 IH10, which was Timberlake Courts at the time, and the 2 handguns at 5015 Pine Club Apartments.
Okay. But she put them in different dumpsters?
Yes, sir.
Did it take a lot of effort to find those guns?
Yes, sir.
To show what's been marked. Let's start with the location of Fuzzies. Is that, map actually gives a good location of Fuzzies?
Yes, sir.
And it's not very far from where the house on LG was?
Yes, sir.
Have you, look at States Exhibits 11 through 17 and ask if you're familiar with those?
What was the number on the,
8.
thank you.
Yes, sir. That's the natural depiction.
These photos fairly naturally depict where the gun was actually recovered from.
Yes, sir.
With our States 8 and 11 through 17 in essence.
Judge, we've seen 8 and 11 through 17, and we have no objection.
8 and then 11 through 17 are admitted.
Okay, so we can see on States Exhibit number 8, Fuzzies is located here. This is Avenue A, this is Washington Boulevard, and then this is LG down here, and this is Avenue E. So the house where the murder took place and the robbery took place was here, and so that's really, how far would you say that is? It's not very far, is it?
Less than half a mile.
Now describe for the jury, this doesn't look like a parking lot in an apartment complex. Would you describe for the jury the process in retrieving the firearms?
Yes, sir. Once we went to 5015 Pine and determined that it was a compactor style roll-off dumpster, and it was unsafe for us to go in there to dig through trash, so we had to coordinate with a roll-off dumpster service to come pick up the trash bin and bring it to the Beaumont landfill. Coordinated with the landfill to give us an open, cleared area to dump the trash from that previous weekend, so we could then dig through it to locate the evidence.
Sounds like a fun job.
I don't want to have to do it again.
Show you States Exhibit 12. Did Shirley describe the way the guns were packaged?
Yes, sir.
So you knew what color to be looking for at least?
Yes, sir.
Was that able to help you track it down?
Yes, sir.
And what do we see in States Exhibit number 12?
A pink bat towel.
States Exhibit 13, getting a little closer.
Yes, sir.
State's Exhibit 14, and then State's Exhibit 15. Were these the firearms that were found wrapped in, around that towel, wrapped in that towel?
Yes, sir.
State's Exhibit 16 is a Ruger Security 9mm,
Yes, sir.
and then 17 is a Springfield XDS 9mm.
Yes, sir.
Show what we have marked State's Exhibits 18 and 19. 19 is a turquoise colored Springfield XDS. Is this the gun that was recovered from that dumpster,
Yes, sir.
wrapped in that pink towel?
Yes, sir.
And State's Exhibit 18 is a black Ruger 9, security 9mm.
Yes, sir.
Was this also recovered from that pink towel in that dumpster?
Yes, sir.
And you personally recovered these?
Yes, sir.
Now, we'd offer at this time States 18 and 19 into evidence.
No objection to 18 and 19, Your Honor.
Have they both been made safe,
Yes, Judge.
secured? All right, 18 and 19 are admitted.
Based on your investigation of this case, do you have a firm grasp on what happened at 1830 LG and who was involved?
Yes, sir.
Okay. What did you determine had occurred?
Okay, so I determined what occurred. I determined that Shirley Jackson had driven Paul Westbrook's, Dijon Ivory, and Rogan Dotson initially to this location. That's where they were seen on surveillance. Vehicle first turned around and left. They were later dropped off at a street south of LG Street and let out of the vehicle. Shirley Jackson then left them after they walked off and just drove around, and then ultimately, once she had told us she had gone to the store, we were able to corroborate that. During that time, it was determined that the three individuals, Paul Westbrook, Dijon Ivory, and Rogan Dotson, had conspired prior to go to 1830 Elgin Street to commit a robbery, and that residence belongs to Ahmad Hayden. During the course of the robbery, of course, we know that Rogan Dotson had been shot, and then in turn, Ahmad Hayden was then shot after. Paul Westbrooks and Dijon Ivory fled from that location and were later picked up about the same area that they had been dropped off. Shirley Jackson.
Okay. Now, did you have, I mean, you talked to the witnesses that were in the house.
Yes, sir.
You talked to Shirley Jackson, who didn't go in the house, but had been with them prior to and then afterwards.
Yes, sir.
You know that Rogan Dotson didn't get back into the expedition.
Yes, sir.
But did you have occasion to speak with Dijon Ivory?
Yes, sir.
Did Was there anything that he said different from the way you understand it?
No, sir.
Did you also speak with Paul Westbrooks?
Yes, sir.
Did you give him the opportunity to give a statement to you?
Yes, sir.
Did you ask him about his involvement?
I did. Yes, sir.
And what was his response to that?
He denied it. He denied being involved and having any knowledge of what had taken place.
So he wasn't there, didn't know anything about it, not me.
Yes, sir.
Over the course of your law enforcement career, have you had the opportunity to speak with witnesses, suspects?
Yes, sir.
I've been on few or many occasions.
Many.
Do you have to get a feel for who's telling you the truth and who's not?
Yes, sir.
And after speaking with Paul Westbrooks, did you feel like he was honest with you?
Object to speculation, Your Honor.
Overruled.
You can answer.
Can you repeat the question?
Do you feel like Paul Westbrooks was honest in his account to you?
No, sir. I do not.
So we know that this occurred on April 10th of 2023,
Yes, sir.
and it occurred in Jefferson County, Texas.
Yes, sir.
And there was an aggravated robbery that was committed there at 1830 LG.
Yes, sir.
Is going into someone else's home with firearms, would you consider that an act clearly dangerous to human life?
Yes, sir.
Is a firearm an instrument capable of inflicting serious bodily injury or death?
Yes, sir.
Do you feel like both shootings occurred in the process of, in the furtherance or commission of the felony of aggravated robbery?
Calls for speculation, Your Honor. Object.
Overruled. You can answer.
Yes, sir.
And that robbery resulted in the death of Rovin Dotson and Ahmad Hay.
Yes, sir.
One second, Judge.
Sure.
Now, when you know who you're looking for, you have resources that you can go to try to figure out as much information about them as you can with information.
Yes, sir.
The person that you interviewed, you said was Paul Westbrooks.
Yes, sir.
Was that Paul Edward Westbrooks Jr.?
Yes, sir.
And are there a couple of other names that he's gone by, like Paul Westbrooks and Paul Westbrooks Jr.?
Yes, sir.
That person that you interviewed that denied being a part of it, but that you feel is a part of it, do you see him in the courtroom here today?
Yes, sir.
Would you point him out and identify an article of clothing that he's wearing, please?
Yes, sir. It's that gentleman there with the khaki colored suit jacket.
Your Honor, let the record reflect he has identified the defendant in this case.
The record will so reflect.
That's witness.
Thank you. Mr. Smith, Mr. Vasquez?
Thank you, Your Honor. Detective, how are you?
I'm good. How about yourself?
Good, thank you. With all due respect, no sarcasm intended, you're not clairvoyant, are you?
No, sir.
You can't see into another person's soul.
No, sir.
And you've talked to a lot of people, interviewed a lot of people in your time in the police department. Some stories are true, some are not true. There's more than one Ford Expedition in Beaumont, Texas, is there not?
There is.
You didn't actually see Mr. Westbrooks in a Ford Expedition, did you?
No, sir.
You didn't actually see him get dropped off or picked up anywhere, did you? You didn't see him in the course of a robbery, did you?
No, sir.
You brought your report with you to court.
Yes, sir.
May I see?
Sure.
May I approach you?
Yes, sir.
Thank you. Thank you. Thank you. I want to make sure it's what I have. I misplaced stuff sometimes. Did you interview Miss Jordan? Melissa Jordan?
Melissa Jordan? I did not personally.
Did you interview Miss Buckaloo?
I did.
Did you interview Mr. Macy?
I did, yes, sir.
After those interviews, did without telling me what anyone said, after those interviews, were you looking for a person with the first name Mike?
Yes.
And you interviewed Michael Smith,
That's correct.
and he was ruled out as a suspect.
Yes, sir.
Did you interview Michael Pelican? Can't recall?
And, I can refer back to my report.
Sure. If you would.
I don't have a Michael Pelican in my report. It's possible another detective may have interviewed him.
Do you have any independent recollection of that name?
I do. It had come up, yes, sir.
Do you know of any other detective talked to him?
I'm sure there was. I can't recall right off the top of my head.
Are you I don't know what you call it, the chief detective or the lead detective in this?
The lead detective, yes, sir.
So would you know if another detective interviewed Michael Pelican?
Yes, sir.
But you can't tell us today?
Not right off the top of my head.
Did you interview anyone with the nickname Day Day? Doesn't ring a bell?
I don't recall.
Steve? Did that name come up for any reason? For any person of interest or someone you wanted to talk to? I say person of interest because I think I've heard it on television or something. I've never actually seen it here before. That name doesn't ring a
I
bell?
don't recall the name, Steve.
Was a shotgun recovered at the scene?
Yes.
Was that analyzed for anything?
No, sir.
Not analyzed for DNA or fingerprints or anything like that?
No, sir.
Why not?
This was located in a closet, inside of the residence. And was not a part of the actual crime scene itself.
Well, if witnesses said the shotgun was part of the crime scene, I think it's in your report, the shotgun was used, would that be something you'd need to look at? Something that might need to be analyzed?
Not if it was. I don't recall the shotgun being used in this instance, sir.
You don't recall after speaking with, I don't know if it's Miss Buckaloo or Miss Jordan, talking about one of the suspects with a shotgun?
I can refer back to my report and look and see if I notated it in there.
Would you please?
No, sir, I don't have anything about the shotgun in my report.
Might it be in another officer's report or another detective's report?
It's possible.
Should it have been analyzed if it were used in this type of incident?
So in my report, I actually did locate it, where an officer did locate a shotgun in a closet, and it was removed from the residence and secured in a patrol vehicle. But I did not get any witness testimony about a shotgun being involved.
Did you ever actually see it in your course of the investigation?
I don't recall, sir.
How about a pistol, or I don't know if it's a pistol, revolver, or 38? Might that be in your report, with being found at the home?
No, sir.
No?
No, sir.
You wanna look, or are you sure that?
I can take a look, but, if there was one located, it too would have been, it would have been analyzed.
It would have been?
Yes, sir. If, like I said, if one had been located.
What is a EIG 38? Is that a brand, a EIG, do you know?
I'm not sure.
The Ruger, the black Ruger that you located in the dumpster, do you know who the owner of that is?
Yes, sir.
Can you tell us who the owner of that is?
That gun belonged to Shirley Jackson.
How did you determine that?
Anytime we get, well, she identified the gun as it belonging to her.
Did you check, how do you check to find out who owns a pistol when you just find one laying around somewhere?
And an ATF trace is done on firearms.
And she came back as the owner?
I don't recall, right? I don't have it with me, no, sir.
Would a person have to register their firearm
Yes,
in
sir.
order for them to?
Yes, sir.
How about that one, the T or the turquoise handled one?
Yes, sir.
Could you determine who that belonged to?
Again, that same gun would have an ATF trace on it.
Do you know who the owner is?
From the investigation, it was determined that it belonged to Ahmad Hayden, but like I said, I don't have the ATF trace with me to determine exactly if, I don't remember.
So the black gun determined it was Shirley's, and the turquoise gun, Mr. Hayden's.
Yes, sir.
Were Miss Buckaloo or Miss Jordan able to identify Mr. Westbrook in the photo arrays you showed? Or the detective showed?
No, sir.
You don't know?
I don't recall.
You don't recall whether they could identify him or not?
No, sir.
Well, that'd make a big difference in the case, wouldn't it, if they could identify him or they couldn't?
They had masks on their faces, so we're able to determine that.
They all had masks?
Sir, I don't recall.
Okay. Did you determine who the owner was of the house, or whose name came back on the water bill at 1830 Oak?
Yes, sir, I did.
Mr. Broussard,
Yes, sir.
and that was Hayden's.
It was uncle by marriage, I believe.
Did you know Mr. Hayden from any previous dealings?
No, sir.
Do you know if he sold drugs out of the house? Or do you know?
Did I know that personally prior to? No, sir, but I've come to learn that in the investigation.
So everything you just articulated for Mr. Smith, the scenario, that came from Ms. Jackson.
From Ms. Jackson and the other today. Yes, sir.
Got one moment here.
Sure.
No further questions. Thank you, Detective.
Thank you, Mr. Vasquez. Mr. Smith?
Yes, Judge. Okay, there was a focus on the two 9mm that were recovered, right?
Yes, sir.
Why was there a focus on those two particular guns? It was because those were the ones you felt were actually fired in the house?
Yes, sir.
The shotgun that Mr. Vasquez mentioned and has maybe been mentioned by other witnesses, was there any evidence it had been fired in the house?
No, sir.
Was there any evidence about it being done anything other than pointed at people?
No, sir.
Okay. And it was actually picked up by one of the officers and put in a patrol car before you even got there.
Yes, sir.
Is that correct?
Yes, sir.
So you didn't deal with it at all?
I did not.
It was turned into evidence by patrol officers?
Yes, sir.
And the reason that we know Mr. Westbrooks was involved and the story checked out was not just because of what Shirley told you, and not just because of what Dijon Ivory told you. It was because those things fit. They made sense. They fit in with the other evidence that you found. There was corroboration on every part of all of that.
Yes, sir.
Wasn't there?
Yes, sir.
Did any evidence that was discovered in the case come up with anything that would dissuade you from the fact that 3 men went into that house acting together to commit an aggravated robbery?
No, sir.
Anything in your investigation, the evidence that was recovered, lead you to believe that anybody else was involved with this other than Dijon Ivory, Roland Dotson, and Paul Westbrooks?
No, sir. Just those three.
And you ran down every lead that you were able to track down in this case?
Yes, sir.
No doubt in your mind, those are the 3 men involved.
No, sir.
That's great.
Thank you. Anything else, Mr. Vasquez?
No, Your Honor, no questions.
Any objection to Detective Sarant being excused?
No, Judge.
Subject to recall.
Thank you, Detective. Obviously, if they need you to come back, if you'll make yourself available and you're placed under the rule, and you know what that means.
Yes, ma'am.
Have a good day. You're free to go. You may call your next witness.
That calls Hunter Jones.
Good morning, sir.
Good morning.
If you please raise your right hand, do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can have a seat. You may proceed.
Good morning. Would you state your name, spell for the court, please?
Sure. My name is Hunter Jones. It's HUNTERJONES.
And how are you currently employed?
I'm a forensic scientist and more specifically firearms examiner with the Jefferson County Crime Lab here in Beaumont.
And what training and experience do you have as a firearms handler?
I have extensive on-the-job training with senior examiners at the lab. Also was a participant or member of the National Firearms Examiner Academy, excuse me, which is a program that's put on by the ATF, or Bureau of Alcohol, Tobacco, Firearms, and Explosives. This was a program that took place at the headquarters in Maryland. I had experts from around the country come in to work with you on using a microscope for examining tool marks on
fired projectiles or bullets, as well as fired cartridge cases, working with firearms on their functionality, different parts, multiple manufacturing tours for ammunition plants, firearm manufacturing plants, tool making plants, to see all the processes that take place through those different steps and components. And I also have a license through the Texas Forensic Science Commission for firearms examination, which included passing a test and includes continuing education hours. Every year there's a certain amount of hours to withhold that license or maintain that license rather. And there's other continuing education hours for the lab standards, as well as proficiency tests that are passed annually to do this type of work and make sure expected results are given to maintain casework.
And is the lab in which you work, is it accredited?
Yes, sir.
Now, have you testified as an expert in firearms in district courts here in the state of Texas
Yes, sir.
and in Jefferson County?
That's correct.
Been on few or many occasions?
I would say many occasions.
Now, let's turn our attention to your case, your lab number RCL-23-120155. Did you perform some analysis and show you what has been entered into evidence as states 18 and 19? 18 is a black Ruger.
Yes, sir.
Your initials on there somewhere.
Yes, sir. I'm right here.
I'm going to show you States Exhibit 19, Springfield, XDS.
Yes, sir. At the top there again, yes, sir. Here, here.
So you performed analysis on States Exhibits 18 and 19. Would you describe that for the jury, please?
Sure. The analysis on these two exhibits would have started with a function examination. So those would be checked out from our secure vault by me. There would be some visual inspection, looking at the condition as received, documenting that along the way, as well as noting the safeties, obviously checking to make sure the firearm isn't loaded to begin with or have an obstruction in the barrel. And after this process is documented and it looks operational in the laboratory, I then proceed with the actual function exam, which includes test firing that at my facility as well, into a water tank that we have, which allows me to fire bullets and recover them without extra marks, so I can use them for comparisons or to evaluate the firearm itself and its ability to produce tool marks. And the cartridge cases are also collected during that process.
Okay. Now, were you also provided with a cartridge case in this particular case?
Yes, sir.
And explain to the jury, what are we talking, when we say a cartridge case, what are we talking about?
So the cartridge case comes from the original cartridge or full round of ammunition. So pre-firing, you have the usually brass or nickel colored and metallic part of the full cartridge, which contains the powder and has a primer on the back. And then on the end of it, it will end up leaving the barrel of the firearm as a projectile or bullet. It's usually the flat round, or sometimes if it has a hollow point, it's the end with a hole in it on copper jacket, or sometimes steel or aluminum or nickel colored as well. And upon firing, those two components separate, so the bullet travels out of the barrel, propelled by the explosive gases and powder that's discharged. And that cartridge case, depending on the weapon, either is retained in the weapon, in the case of like a revolver or a single shot, oftentimes, or in a semi-automatic fashion, which is what these two weapons are, it's expelled, typically extracted or ejected, and that's the empty cartridge case that I'm referring to.
Okay, so there was a Blazer brand 9mm Luger cartridge case that was submitted along with these two firearms.
That's correct.
Were you able to examine and analyze that cartridge case?
Yes, sir.
Were you able to determine if that cartridge case was fired from either States 18 or 19?
Yes, sir.
Was it?
It was my opinion that that Blazer brand 9mm Luger caliber cartridge case was identified as fired in the my Exhibit 3 firearm, which I believe is going to be the State's Exhibit 19. That would be the Springfield.
That would be the turquoise gun that we see up on the screen there.
That's correct.
But that was the only cartridge case that you were given.
That's correct.
And were you also given a projectile to compare?
Yes, sir.
And were you able to make a successful comparison on that?
On my examination and comparison of the projectile, there was a significant portion of that copper jacket missing, which means from my examination, the tool marks necessary to make a association with any firearm largely were missing, and I documented very limited information being present. So my resulting conclusion or opinion on that was that it was inconclusive. It was evaluated and consistent in size, shape, and weight with a 9mm Luger caliber, but any further associations or information could not be given.
Now explain to the jury, people that may not be quite as familiar with firearms, when we're talking about, we call it a bullet, right? Has a cartridge, which is the round case with the primer on the bottom, the powder inside, and then the projectile is fitted inside of that case.
Yes, sir.
But when you say, in this particular case, the copper had separated, the jacket had come off, would you explain that to the jury? What is a copper jacket?
Sure. A large portion of ammunition that has been manufactured, at least up to this point, has been a lead core with a jacket, and often copper jacket surrounding that. Lead, according to the industry, tends to gunk up a barrel or stick in a barrel more, so it's a cleaner firing process, and maybe less cleaning between firing and whether it's range or personal use or whatever the use may be for the barrel. So part of the reason was, I guess, cleanliness for firing through the barrel and maybe retention of that projectile better, because lead is known to melt or deform easier as it's a softer metal. So there's often what you find is a jacket enclosed on, whether it be a hollow point or a total metal jacket or a full metal jacket, encasing that lead projectile or lead core.
So that's common on bullets that you would buy at Academy or anywhere. They're gonna have that jacket because people prefer that because it keeps your gun clean.
It's very common.
But as that projectile goes through the barrel, it begins to spin, and sometimes that jacket will separate, especially if it hits something, right?
Yes, that's correct. And in my experience with this particular brand of ammunition, Blazer, I don't know what the brand may be for the projectile, but the cartridge case was clearly marked. And when I test fire this brand, the jacket separates even on my test firing in the water tank. So it will be consistent with what I'd seen in Blazer as well. But either way, with that, yes, with encountering an object of sorts, especially with this type of ammunition, it's common for that jacket to separate, which takes the marking surface interacted with the inside of those grooves in the barrel or lands in the barrel. That's where those marks reside. So when that jacket material is gone, there's less to look at.
Okay. So your analysis in the exhibits in this particular case, it is your opinion that both states 18 and 19 were functioning properly, which means they were able to fire a projectile through the barrel just like it's designed to do from the factory.
Yes, sir.
And one of the casing that you were given was fired from one of these firearms.
In my opinion, yes, sir.
And the second one, there wasn't enough evidence to say for sure that it was, but there was nothing that would exclude it either.
That's correct.
Thank you.
Yes, sir.
Pass it.
Thank you. Mr. Vasquez?
Thank you, Your Honor. Hello, Mr. Jones.
Hello, sir.
Now bear with me, I don't know guys like you and Mr. Smith. He said, I think the three he said were full metal jacket, hollow point, what was the other one he mentioned?
I believe I said total metal jacket.
Today, I mean, in conclusion, what they brought you was a shell casing that you determined to come from this gun up on the screen. correct? The teal gun,
Yes, sir.
Springfield. And a projectile, and you couldn't determine where that came from.
That's correct.
And they were both 9mm?
Yes,
The
sir.
weapons?
Yes, sir.
The shell was a 9mm?
Yes, sir.
Projectile, can you tell?
It was consistent in size, shape, and weight with 9mm.
Can a 9mm weapon fire a 380?
It could, yes, sir.
Some weapons can, some can.
That's correct.
What's it, well, I was just curious, it's got nothing to do with the case. When I see live round, what does that mean? Just a bullet by itself
That would be the full cartridge, yes, sir.
that you buy in the store?
Correct.
But in this case, we're talking about one shell used in and one projectile.
Yes, sir.
Thank you, sir.
Thank you, Mr. Vasquez. Anything else?
Yes, one clarification, Judge.
Sure.
Mr. Vasquez asked you about a 380. 380 is the same diameter. It's often referred to as a 9mm Kurz or short 9mm. So it's the same width. It would fire through. You could technically fire one. It may not give you the exact results that you're looking for, but 380 is similar in size to the 9mm.
That's correct.
All right, anything else, Mr. Vasquez?
No, Your Honor.
Any objection to Mr. Jones being excused?
No, Judge. Subject to recall.
Thank you, Mr. Jones. You're excused and you're placed under the rule, and you know what that means.
Yes, ma'am.
Have a good day.
Thank you.
And the doctor that is going to come testify, the pathologist, cannot come until after lunch. It's the autopsy doctor. You guys have heard some things on the news about some people at the plant that anyway, he's busy this morning handling that, and law enforcement is also involved, and so we can't really pull him away. So we're going to take a long lunch. It's 10:30. I'd like to get started back at 1 o'clock. Please keep in mind all those instructions you were previously given. We're going to stay here, work also on the charge, so that when we get to that point, we'll be ready to go and get the case to you as quickly as we can. All right, keep in mind all those instructions. If everyone else would remain seated, you're excused until 1 o'clock. All right, anything we need to take up before we take a break?
Question, I guess, from the court, Judge. Anticipating that Mr. Westbrook's in the case we get to punishment will not stipulate to his priors, do I need a written motion for fingerprint, or will an oral motion be sufficient?
It depends. I mean, if you want to visit with Mr. Westbrooks and see if he would agree to that first before we do it. I think if he does not agree to do the fingerprint, then probably cleaner to go ahead and file a quick motion, and just so that there's something in the file for appellate purposes and things like that. But if Mr. Vasquez, if you'll explain to him, obviously what we're talking about, I'm going to order it. But if you need me to do that for appellate purposes, we'll get that done. I'm printing out. All right, let's go off the record. Okay, let's go on the record. State's attorney's present, defendant and defense counsel are present. Is there anything we need to take up before we bring the jury in, Mr. Smith?
Nothing stated.
Mr. Vasquez?
No, Your Honor.
All right, you can bring the jury in. cooled off in here. I don't know if it's, why it would be so different. All right, let the record reflect the jury seated, state's attorney's present, defendant and defense counsel are present. Mr. Smith, you may call your next witness.
State calls Dr. Christopher Jeffrey.
Good afternoon, sir. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can have a seat. That microphone moves a little bit. If you'll just pull it over. There you go. And the seat doesn't move, so it doesn't quite match up. You may proceed.
Would you state your name for the record and spell it for the court reporter, please?
My name is Christopher Geffrey. It's spelled Christopher, and the last name is spelled Geffre.
And what is your occupation?
I am a forensic pathologist.
And would you tell us what educational background, professional training you had that qualify you in the field of medical pathology?
After finishing college at the University of Arizona, I did a MD PhD program. I finished that in 2012 with both my MD and my PhD. I then did a 4-year residency in pathology, followed by a 1-year fellowship in forensic pathology, which is being a medical examiner. Then I took all of my appropriate testing, and I'm board certified in anatomic, clinical, and forensic pathology.
Would you tell the jury what is forensic pathology?
Forensic pathology is a type of medicine that the doctors are determining cause and manner of death.
And in your capacity as a forensic pathologist, do you perform autopsies?
I do perform autopsies.
Okay. And let's go, well, do you perform autopsies for Jefferson County?
I do.
And have you testified as an expert in forensic pathology in district court before?
I have.
What company is it that you work for?
I work for the company called Forensic Medical Management Services.
And is that the company that performs the autopsies for Southeast Texas, for a lot of the adjacent counties?
Yes, we contract with most of the counties in Southeast Texas to perform autopsies.
Have you worked for them, or were you working for them back in April of 2023?
I was.
And let's talk about in Texas. At whose request do you conduct autopsies?
The request is usually generated by the Justice of the Peace, or the JPs.
Okay. And what is an autopsy?
An autopsy is an examination of the body. We do an external exam where we look at the outside of the body and we look for any diseases or any injuries that may be on the body. And then we do the same thing on an internal examination where we look at the inside of the body and all the internal organs.
During your career, approximately how many autopsies have you performed?
I probably perform between 3,000 and 4,000 examinations.
And you said you testified as an expert in forensic pathology. Has that been on few or many occasions?
Probably many. I don't keep specific track.
Gotcha. Now, on April 11th, did you actually conduct the autopsy on Ahmaud Hayden and Rowan Dotson?
I did not.
But did a pathologist that worked for Forensic Medical perform those autopsies?
Yes, my colleague who was in Texas at the time performed those autopsies.
That was Dr. Moisef,
Yes, that was Dr. Moisef.
and she has now left Forensic Medical and has left the state of Texas.
Correct. I believe she's in Georgia now, doing the same job, but for a different state.
Okay, so have you had an opportunity to review the report and the photographs that were taken during the autopsy and made shortly thereafter by Dr. Moisef?
I have.
Are you familiar with the autopsies of both Rowan Dotson and Ahmaud Hayden?
I
I'm going to object to the questions and answers involving Mr. Hayden. They're not relevant in this trial.
I would disagree, Judge. This is all one
situation that would be hard to unwind. I mean, both of them were killed in the same room at virtually the same time, and I feel like it is relevant.
Obviously, the main issue is the death of Mr. Dotson, but I do think that they're intertwined. So I'm going to overrule your objection, but we're not going to go, I don't want to go completely into the other as much as you would Mr. Dotson.
Okay.
Does that make sense?
That's fine.
Okay.
Okay, let's begin with Mr. Dotson's autopsy. Was there anything unusual that you noticed about the autopsy of Rovin Dotson?
I mean, he was shot. I don't know.
Okay. Let me, can I approach this?
Yes, sir.
Show what I marked as State's Exhibit number 26. This is,
It's an autopsy authorization form. When the decedent, Rovin Dotson, originally came to our office, he was unidentified, so we identified him by a unique characteristic called, I believe, Farmer Joe. Subsequently, he was identified and his name has been changed to the appropriate name.
but originally when they did that autopsy, they did it under the name of Farmer Doe.
Correct.
At this time, this would be a copy of the authorization to perform the autopsy signed by the Justice of the Peace
It is.
for the person that they, since they had no actual name, they called him Farmer Doe.
That's correct.
No, at this time it always takes to the 26 in the evidence.
We've been provided this, Your Honor. We have no objection to 26.
State 26 is
State 26.
admitted.
Okay. Can you describe the general condition of the body when the autopsy began?
He was a relatively healthy individual with a defect to his abdomen,
When you say defect, what do you mean?
gunshot wound to his abdomen.
What was the result of the external examination?
The external examination, he was a fairly healthy, middle-aged, young individual. He had a gunshot wound to his right abdomen, but other than that, he was relatively healthy.
And where exactly on his body was that gunshot wound?
His gunshot wound was in the right abdomen.
Let me show you what's been marked. State's Exhibits 27 through 32.
Ask if you recognize those.
I do.
Did these photos, were these taken at the time of the autopsy?
Yes.
And did these photos fairly and accurately depict the condition of the body of Rovin Dotson when his autopsy was performed?
To my knowledge, yes.
We would offer State's Exhibits 27 through 32 in the evidence.
Judge, our only objection is to Exhibit 31 and it's duplicative of 32.
What's your response?
Judge, 31 just shows the wound itself. 32 actually puts the scale there so that you can see the size of the hole.
That's overruled. States 27 through 32 are admitted.
Would you describe what we see in State's Exhibit 27?
That is a picture of the decedent's ankle with his identifications. It has a unique case number, the 23-0356 BMT, that every decedent gets their own unique number. It's also the county that he was found deceased in, and then his name at the time of autopsy and the date of death, I believe.
Okay, and that 230356 BMT, that is a police department number, or that is a?
That is a forensic medical management services number that we use, and we make a unique number for every decedent.
So you assign that actual number?
That's correct.
And this is what Roland Dotson looked like? That was his face?
That's correct.
Okay. The State's Exhibit number 29, the gunshot wound that you're talking about is just below the unique number?
Yes, you can see the white ruler on his abdomen. Just below that, you'll see a circular defect with a black ring around it. That's the entrance gunshot wound. And then below that, you can see his belly button.
And then State's Exhibit number 30 is just a closer up view of that gunshot wound?
That's correct. That's a higher magnification image of the gunshot wound. In the center of the black circle, you can see the round defect, and that's the gunshot wound itself. Surrounding the entrance gunshot wound is that black discoloration, which is soot, and that is from the gun firing.
So when you see soot and stippling around the entrance wound, what does that tell you as a pathologist?
As a pathologist, we use soot and stippling to help determine range of fire. Soot indicates that it was a contact gunshot wound, meaning the muzzle of the gun was up against the skin when it was fired. Stippling is unburnt gunpowder that slaps into the skin and causes little punctate red abrasions. And that indicates an intermediate range of fire, meaning somewhere between inches and feet away, depending on the gun and the type of ammunition.
Okay. So based on this particular kind of wound with the way it presents here, how close would you say the gun was to the abdomen of Roland Dotson when it was fired?
I would say it's touching, if not close to touching.
And could you describe for the jury, let's keep going.
State's Exhibit number 31. Could you describe what we see in State's Exhibit number 31?
This is a gunshot wound of the decedent's back. At the top of the image, he's being propped up on his left side. The top of the top of the picture would be his head, and at the bottom of the picture would be his feet. And the defect that you see to the left of the white ruler is an exit gunshot wound.
Okay. And then State's Exhibit 32, just a little bit closer, it actually gives us a scale there.
That one, this wound does not appear to be round like the first one. Could you describe why that might be?
Typically, exit gunshot wounds aren't round. Entrance gunshot wounds tend to be more round in terms of shape than exit gunshot wounds.
And what was the result of the internal examination of Mr. Dotson?
In this situation, the decedent, his gunshot wound, it went through his soft tissue and skin of his abdomen. It then went in through the mesentery, which is the soft tissue that supports all of your intestines. It then went through his inferior vena cava, which is the major vein that takes the blood back to the heart. And then went through his right kidney, and it exited out his back.
So that would be one bullet entered in his abdomen, went through and perforated and came out the back.
That's correct.
And no other signs of internal trauma other than the damage caused by that one particular bullet?
Correct. The bullet caused those damages to those organs, and it caused a tear to the liver as well.
And as part of the autopsy, was toxicology also performed?
It was.
And you recall the results of that toxicology?
Not off the top of my head, I would have to refer to the tox report.
Approach, Judge?
You may.
Shows been marked as State's Exhibit number 39. This is the autopsy report.
Yes, that is the autopsy report and the toxicology report.
Okay. And can you tell the jury what drugs and substances were found in his blood?
In his blood, they found ethanol, which is alcohol. They found caffeine, which is from coffee or a Coke. They found cotinine and nicotine, which is from cigarette smoking. And then they found methamphetamine and amphetamine. So methamphetamine is the illicit substance that people abuse recreationally, and amphetamine is a metabolite of that. When your body breaks down the methamphetamine, it turns into amphetamine.
And do you recognize State's Exhibit number 39?
I do.
Is this a true and correct copy of the autopsy report along with toxicology of the Roland Dotson?
Yes.
Your Honor, this time would offer State's Exhibit 39 into evidence.
No objection to State 39, Your Honor.
States 39 is admitted.
During the examination of Mr. Dotson, did you find any evidence of disease that would have kept him from living a normal, active life?
I think his heart was a little heavy, but I don't think it was significant enough to have caused his death beyond the gunshot.
And based on the autopsy, do you have an opinion as to the cause of death?
I believe his cause of death was from a gunshot wound to the abdomen.
And what about the manner of death?
The manner of death in this case I would classify as homicide.
Now, a similar autopsy was performed for Ahmaud Hayden,
That's correct.
and in that, what was his cause of death?
His cause of death was a gunshot wound to the trunk or the torso.
Was it similar to Roland Dotson's?
It was a single gunshot wound that entered and exited the body, and it resulted in his death.
Was the entrance in the front or the back?
His entrance was in the left back.
And then the exit wound, was there also an exit wound?
There was an exit wound on his right abdomen.
And what damage did that bullet do in his case?
That bullet went through his aorta and his right lung, and it also caused some tears to his liver as well.
Now, based on those two wounds, which one would have died faster, do you believe?
It's tough to say, but in this case, the aorta is a major artery, and it has a lot of blood pressure behind it. So in that case, gunshot wounds to the aorta tend to bleed a little bit quicker than gunshot wounds to the inferior vena cava, because that is a low pressure environment.
And do you have an opinion as to the cause of death of Ahmaud Hayden?
His cause of death was a gunshot wound of the torso.
And the manner of death?
His manner of death was classified as homicide as well.
And I'd offer actually an approach. Is this a true and correct copy of Ahmaud Hayden's autopsy report?
Yes, it is.
Not this time, I'd offer State's Exhibit 38 and
30, I'm sorry?
38.
No objection to States 38, Your Honor.
It's admitted.
Pass witness.
Thank you, Mr. Smith. Mr. Vasquez?
Thank you, Your Honor. Doctor, how are you?
I'm doing well, and yourself?
Fine, thank you. Regarding Mr. Dotson, or former Doe,
Okay.
you said stippling versus soot. This contained stippling?
It contained both. It had a little rim of stippling and it had a circumferential rim of soot.
And soot is, I'm gonna ask you to explain again. Soot is when you're up close?
Yes, soot is burnt gunpowder. It exits along with the bullet from the gun, and if the gun is close enough to the skin or the clothing, you can see the burnt gunpowder as soot up along the skin or the clothing. It'll be that black ring of discoloration that we saw in the entrance gunshot wound. Stippling is unburnt gunpowder that also leaves the gun with the bullet, but those unburnt gunpowders hit the skin and cause little bitty abrasions.
And you told Mr. Smith that in this case, the muzzle was right up on him, right next to the body, and it was
Correct.
fired. And stippling would be inches to a few feet?
In some situations, in this case, the soot tells me that it was more of a contact gunshot wound, and the stippling could be more from an angled, the projectile being or the gun being slightly angled to his body.
So whoever shot Mr. Dotson ran right up to him and put the gun against his skin?
I don't know the exact sequence of events, but I do believe the gun was next to his skin when it was fired.
Were you able to find a projectile or a bullet?
Not from the body.
And looking at the autopsy report, looking at the pictures, your report, are you able to tell what caliber bullet it is?
I cannot.
And you can't tell what kind of gun it is?
I cannot.
And you can't tell who fired the gun?
I cannot.
Thank you, Doctor.
Thank you, Mr. Vasquez. Mr. Smith, anything else?
Yeah, just briefly, Judge. Dr. Gifford, you can't tell us what caliber the bullet was. You can't say if it was a .380 or a 9mm or a .38 or a .45.
The only way to determine the caliber would have been to collect the projectile.
But can you say that this was a one singular track wound versus a shotgun type wound?
Yes, this would be more consistent with a handgun and then a shotgun. This does not appear to be a shotgun wound.
A shotgun wound would look completely different and do a lot more damage.
In theory, depending on the shotgun and the ammunition, but shotguns tend to either be birdshot or buckshot. So those entry gunshot wounds tend to be a little bit larger in diameter than a handgun.
No further questions.
All right, anything else, Mr. Vasquez?
Can I have one moment, Your Honor?
Sure.
No question, Your Honor, thank you.
All right, thank you, Mr. Vasquez. Any objection to Dr. Geoffrey being excused?
Not from the state.
No, Your Honor.
Thank you, doctor. You're excused, and you're placed under the rule, and you know what that means as well. Don't discuss your testimony with anyone else or
Yeah.
other than the lawyers or investigators.
Not a problem.
Thank you, sir.
Thank you.
Okay, let the record reflect state's attorneys present, defendant and defense counsel are present. I guess before we bring the jury in, just so that we can maybe avoid some back and forth possibly, do you anticipate this is going to now be your last witness, Mr. Smith? Mr. Vasquez, based on that, do you want to go ahead? Is there anything that you want to put on the record or prior to that so that we don't have to break and then break again possibly for the final charge conference?
Well, Your Honor, I would ask the court to admonish Mr. Westbrooks about testifying.
Okay, and have y'all discussed, obviously, his ability to elect whether he chooses to testify or not testify?
Yes, Your Honor.
Mr. Westbrook, just, you can, if you will, just stand up so you can answer loudly so that make sure the court reporter can hear you, okay? Have you discussed with your attorney, Mr. Vasquez, your right to testify and also your right not to testify?
Yes, ma'am.
And you know, if you don't testify and you elect not to, that there will be a specific paragraph in the court's charge that instructs the jury that they cannot take that into consideration for any reason. And you've talked about that with Mr. Vasquez as well.
Yes, ma'am.
And based on that, do you wish to, or I guess you can, Mr. Vasquez, have you discussed and does your client wish to testify or not?
Judge, I'm gonna let him answer. I don't think so, but I'm gonna let him answer for himself.
No, ma'am.
Okay, perfect. Thank you, sir. You can have a seat. All right, then, we can bring the jury back in. And I guess based on that also, there's no other changes that need to take place with the court's charge then?
Not that I saw.
No, Your Honor, not that I'm aware of.
I'm sure we'll find them as you read it.
So are y'all gonna want a break or can we go right into it? Get it printed. All right, let the record reflect the jury seated. State's attorneys present, defendant, defense counsel are present. You may call your next witness.
State recalls Detective Saeed Sarant.
You can go ahead and have a seat. You're still under oath, sir. You may proceed.
Can I approach it?
Yes, sir.
Detective, just a couple more questions. Now that the pathologist has testified, State's Exhibit number 28 has been introduced into evidence. Do you recognize the subject of State's Exhibit number 28?
Yes, sir.
Who is that?
That's Robin Dodson.
And then I'll show you what's been marked as State's Exhibit number 21. Do you recognize him?
Yes, sir.
And does that photo fairly and accurately depict him?
Yes, sir.
Okay.
That's,
At this time, we'd offer State's Exhibit number 21 into evidence.
Judge, I'm gonna object to 21 as to relevance.
21 is who?
Mott Hayden. Just identification photograph.
What's the relevance?
Well, it was all one course. This person we know is dead. This person was also died in that same incident, Judge.
I'll overrule the objection. 21's admitted.
Who is that?
that's Amon.
These are the two men that died at 1830 Elgin here in Beaumont on April 10th, 2023.
Yes, sir.
That's it.
Thank you. Any other questions of Detective Sarant, Mr. Vasquez?
Have one moment, Your Honor.
Sure.
No questions for the detective, Your Honor.
All right. Any objection to him being excused again?
No, Judge.
Thank you for coming back over, Detective. You're excused. You may call your next witness.
At this time, state rests.
All right. Thank you, Mr. Smith. Mr. Vasquez, are you ready to proceed?
Defense rest, Your Honor.
All right, thank you, Mr. Vasquez. All right, ladies and gentlemen, what that means is that you have heard all of the evidence that will be presented in the case. The next thing is for me to read that court's charge to you, which we have been working on, and I am finishing at this very minute. Mr. Smith, Mr. Vasquez, do either of you need a break for any reason, or can I just print out some copies and I go ahead forward?
State does not need a break, Judge.
We're ready.
All right, give me just a second. I'll get, it's printing. I just printed it to the office instead of in here. Okay, there should be 4 copies. Okay, thanks. We can just all sit awkwardly and quiet for a minute. Deputy Millhouse. Since they both rested, if y'all want to let somebody know, they can take these on back now. You want me to text somebody or you want to got it? Okay. Here she comes. I got one for Miss Muffino as well. All right, ladies and gentlemen, I'm going to read to you now the court's charge. Clause number 23, DCCR 0329, the State of Texas versus Paul Edward Westbrooks Jr. Members of the jury, the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks and Paul Westbrooks Jr., stands charged by indictment with the offense of murder. The defendant has pleaded not guilty, and you have heard all the evidence. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after a careful and impartial consideration of all of the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings, unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request testimony be read back, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state has not proved the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. Your first task will be to select your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with the other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss the case with any court officer or the attorney or anyone not on the jury. 2, you must not discuss the case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. And 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use the form attached to these instructions. The foreperson should sign the line that corresponds to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Insufficiency of testimony of an accomplice in fact. A person cannot be convicted of a crime on the uncorroborated testimony of an accomplice. An accomplice is someone whose participation in the crime would permit his or her conviction for the crime charged in the indictment. You must determine whether Shirley Jackson is an accomplice to the crime of murder. If it was committed, If you determine that Shirley Jackson is an accomplice, you must then also determine whether there is evidence corroborating the testimony of Shirley Jackson. An accomplice is someone whose participation in the crime would permit his conviction for the crime charged in the indictment. A person's participation in the crime permits the person's conviction for the crime if 1. The person both A. solicited, encouraged, directed, aided, or attempted to aid the defendant in committing the crime, and 2. B, not 2B, and B, acted with the intent to promote or assist the commission of the offense. As many times as we read them, it's messed up. Hold on. Where's my number 2? Oh my goodness. I'm sorry. Give me just a second. Mr. Smith and Mr. Bathurst, y'all come see for a second. I don't even see in the one that I would be using this off of that there was a number 2 after or. There's nothing missing, right? There shouldn't be an or. Right. So there should just be a period after B, 1B. Even though that's what I thought. Okay, do you agree?
Yes, sir.
All right, I'm gonna make that. Okay, so instead of or, it's just going to read B, acted with the intent to promote or assist the commission of the offense. A person is not responsible for an offense committed by another if the person is merely present while the other commits the offense. Corroboration of testimony if witness is accomplice. If you find that Shirley Jackson is an accomplice, you must consider whether there is evidence corroborating the testimony of Shirley Jackson. Evidence is sufficient to corroborate the testimony of an accomplice if that evidence tends to connect the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks and Paul Westbrooks Jr., with the commission of the offense committed. Evidence is not sufficient to corroborate the testimony of an accomplice if that evidence merely shows the offense was committed. Testimony of another accomplice is not sufficient to corroborate the testimony of an accomplice. The corroborative evidence, in other words, must be from some source other than accomplices. Proof that the defendant was merely present in the company of the accomplice shortly before or after the time of any offense that was committed is not in itself sufficient corroboration of the accomplice's testimony. That evidence, however, can be considered along with other suspicious circumstances. You cannot convict the defendant on the testimony of Shirley Jackson unless 1. You find that Shirley Jackson was not an accomplice, or 2. You find that Shirley Jackson was an accomplice and there is other evidence outside the testimony of Shirley Jackson that tends to connect the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks and Paul Westbrooks Jr., with the commission of the offense charged, and B, on the basis of all the evidence in the case, you believe beyond a reasonable doubt that the defendant is guilty. The state accuses the defendant of having committed the offense of murder. Specifically, the accusation is that the defendant is guilty under two alternative theories. Primary actor liability. First, the state contends that the defendant, by his own conduct as a primary actor, committed murder. Party liability. Second, the state contends that Dijon Ivory and/or Rovin Dotson committed murder, and the defendant is criminally responsible for this offense as a party because the defendant solicited, encouraged, directed, aided, or attempted to aid Dijon Ivory and/or Rovin Dotson in committing it. A person who does not, by his own conduct, commit an offense may nonetheless be criminally responsible for the conduct of another person. A person is criminally responsible for an offense committed by the conduct of another if, acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. A defendant acts with intent to promote or assist in the commission of an offense when it is his conscious objective or desire to promote or assist in the commission of the offense. A defendant's mere presence alone will not make him responsible for an offense. A defendant's mere knowledge of a crime or failure to disclose a crime is not sufficient. Law specific to this case. The state accuses the defendant of having committed the offense of murder. Relevant statutes. A person commits the offense of murder if the person commits or attempts to commit a felony other than manslaughter, and in the course of and in furtherance of the commission or attempt, or in immediate flight from the commission or attempt, he commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. A person commits the offense of aggravated robbery if, in the course of committing theft and with intent to obtain and maintain control of the property, the person intentionally or knowingly threatens or places another in fear of imminent bodily injury or death and uses or exhibits a deadly weapon. A person causes the death of another if, but for the person's conduct, the death of the other would not have occurred. Definitions. A person intentionally threatens another when the person has the conscious objective or desire to threaten the other person. A person knowingly threatens another person when the person is aware that he threatens another person. A person intentionally places another in fear when the person has the conscious objective or desire to place the other person in fear. A person knowingly places another in fear when the person is aware that the person's conduct is reasonably certain to cause fear in another. In the course of committing or attempting to commit theft means conduct that occurs in an attempt to commit, during the commission of, or in immediate flight after the attempt or commission of theft. A person commits the offense of theft if 1. The person appropriates property. 2. This appropriation was unlawful in that it was without the property owner's effective consent. And 3. The person did this with intent to deprive the owner of the property. A person attempts to commit theft if the person, with the specific intent to commit theft, does an act amounting to more than mere preparation that tends but fails to effect a theft. A person attempts to commit a felony when, with specific intent to commit the felony, he does an act amounting to more than mere preparation that tends to but fails to effect the commission of the felony intended. Deadly weapon means 1. A firearm, or 2. Anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or 3. Anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Excuse me. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt that the defendant is guilty of murder either as the primary actor or as a party. Liability as primary actor. You must determine whether the state has proved the defendant committed the crime by his own conduct. To prove this, the state must prove beyond a reasonable doubt 3 elements. The elements are that 1, the defendant in Jefferson County, Texas, on or about April 10th, 2023, committed or attempted to commit aggravated robbery, and 2, in the course of and in furtherance of the commission or attempt or an immediate flight from the commission or attempt of aggravated robbery, the defendant committed or attempted to commit an act clearly dangerous to human life, namely used or exhibited a deadly weapon, and 3, the act clearly dangerous to human life caused the death of Rovin Dotson. You are instructed that aggravated robbery is a felony other than manslaughter. If you all agree the state has proved beyond a reasonable doubt elements 1, 2, and 3 listed above, you must find the defendant guilty. Liability as a party. If any of you fail to agree the state has proved beyond a reasonable doubt either elements 1, 2, or 3 listed above, you must next decide whether the state has proved beyond a reasonable doubt that the defendant is guilty because he is criminally responsible for the commission of a crime committed by the conduct of another person. This is the case if the state has proved beyond a reasonable doubt 6 elements. The elements are that 1, in Jefferson County, Texas, on or about April 10th, 2023, Dijon Ivory and or Rovin Dotson committed or attempted to commit aggravated robbery. And 2, in the course of and in furtherance of the commission or attempt or an immediate flight from the commission or attempt of aggravated robbery, Dijon Ivory and or Rovin Dotson committed or attempted to commit an act clearly dangerous to human life, namely used or exhibited a deadly weapon. And 3, Dijon Ivory and or Rovin Dotson did this intentionally or knowingly. And 4, the act clearly dangerous to human life caused the death of Rovin Dotson. And 5, the defendant solicited, encouraged, directed, aided, or attempted to aid Dijon Ivory and or Rovin Dotson to commit the offense of aggravated robbery. And 6, the defendant acted with the intent to promote or assist the commission of the offense of aggravated robbery by Dijon Ivory and or Rovin Dotson. If all of you who did not find the defendant guilty as the primary actor agree that the state has proved beyond a reasonable doubt each of the 6 elements listed above, you must find the defendant guilty. If you all agree the state has failed to prove beyond a reasonable doubt either element 1, 2, or 3 listed above, establishing the defendant's guilt as the primary actor, and has failed to prove beyond a reasonable doubt 1 or more of elements 1 through 6 listed above, establishing the defendant's guilt as a party, then you must find the defendant not guilty. You need not be unanimous about the theory underlying your guilty or not guilty verdict. If you all agree the defendant is guilty either as the primary actor, because the state has proved elements 1, 2, and 3 of primary actor liability listed above beyond a reasonable doubt, or as a party because the state has proved elements 1 through 6 of party liability beyond a reasonable doubt, then you must find the defendant guilty. If you all agree the state has failed to prove beyond a reasonable doubt either element 1, 2, or 3 of primary liability, actor liability, and has failed to prove beyond a reasonable doubt 1 or more of elements 1 through 6 of party liability, you must find the defendant not guilty. And then that's signed by myself. Then you have the verdict form. The top is verdict, not guilty. We, the jury, find the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks, and Paul Westbrooks Jr. not guilty. There's a line for the signature and the printed name of the foreperson. And then below that is verdict guilty. We, the jury, find the defendant, Paul Edward Westbrooks Jr., AKA Paul Edward Westbrooks, and Paul Westbrooks Jr., guilty of murder as charged in the indictment. Again, there's a place for the signature and the printed name of the foreperson. So, a little confusing, but if you follow it, you can get where you need to with regard to each of those, the law that applies to the facts in that. Just gonna have to take your time, read it out loud when you get back there. Mr. Smith, the state has the right to open and close.
Please, the court, counsel. Thank you. Ladies and gentlemen, I want to thank you again for your time as jurors in this case. I know this isn't easy stuff to see and hear. We want to think we have a nice, safe community. When you come up on a case like this, you're reminded that people live different lives than we do. People live in fear. Bad things happen right here in our community. That's why we needed you to come in and listen to these facts, to decide if the facts that were presented to you amount to a crime. That's what you have to do. Your job is simple. This phase, the guilt or innocence phase, you have to decide, is the evidence that's given to you enough? If it is, then Paul Westbrook is guilty. If it's not, then he's not guilty. I told you, this was ours. I'll make this list. I check it off as I go through it, and you'll see every item has been checked off with what I have to prove to you. We can all agree, there's no dispute that on April 10th, 2023, in Jefferson County, Texas, right there on LG Street, that an aggravated robbery was committed. In that aggravated robbery, 2 men died. Roland Dotson, the cousin of Paul Westbrook, and Ahmaud Hayden, the owner of that home. Those deaths occurred while they were in the process of exhibiting deadly weapons to commit a robbery. That is a felony that is not manslaughter. Because I had that burden all the way through the trial, I get to talk to you first and I get to talk to you last. I'm going to keep it as brief as I possibly can. I'm going to sit down and let Mr. Vasquez talk to you, and I'm sure he's going to tell you there's always reasonable doubt here. The state didn't give you enough. We'll get up briefly after that and I'll let you know why we have more. And again, I want to thank you for your time. I know it's not an easy job, but I appreciate you doing it.
Thank you, Mr. Smith. Mr. Vasquez, you may proceed.
Thank you, Ron. Mr. Smith, Ms. Polfino, Mr. Westbrook. I join Mr. Smith in thanking you for being here with us. Shirley Jackson is an accomplice by fact. She's not an accomplice by law. She was not indicted. No detective or police officer promised her anything. She provided information. And they told her, you are a witness. We're making you no promises, but right now, while you're telling us this story, you're still a witness. In other words, she saw a way to get out from under all of this. She's got 5 or 6 kids at home. None of them are Mr. Westbrook. And she needs to get back to him. She's got to come with a story. She was with these suspects all day. Says she was sitting around in her car, watching her kids, playing on her phone, listening to music, doing puzzles, and wasn't talking to any of the suspects or any of their family. For several hours, she couldn't put an hour on pinpoint time. Later, couldn't put a pinpoint time on this, around midnight, 1 in the morning, she drops them off in the middle of the night. With no explanation. They don't know where they're going, they ask them what they're doing. She just knows she's supposed to hang around. And drives around in circles. Maybe she sees the end of the building. She stops here, she stops there. She goes to the store, she drives around somewhere else. Does any of that
sense? Does any of that seem a little odd to you? She has no idea where they're going or what these suspects were doing. Without her testimony, there is absolutely nothing implicating Paul Westbrook's in these allegations. It all rides with her. There's no DNA in that Ford Expedition putting Mr. Westbrook there. There's nothing in that home, Mr. Hayes' home, putting Mr. Westbrook there. There's no other evidence except Miss Jackson. She's an accomplice, and her testimony has to be corroborated, verified, vouched for, backed up by some other source, not just what she says that day. No one saw Paul Westbrook. No one saw him, not one witness. Miss Jordan, Miss Buckaloo, Mr. Mason, none of them could. One of the lady witnesses, Miss Buckaloo or Miss Jordan, says a shotgun was used in the crime. Shotgun was never analyzed. It's taken, but not analyzed for DNA or anything else. All that you have are these pistols, if I can find them, that were that Miss Jackson led the police to. This one they found, and Hunter Jones, the ballistics expert, said one shell casing from Mr. Hayden's home was found. It came from that gun. This weapon, Miss Jackson says, is hers. That's it. No casings, no bullets, no evidence, no DNA. She just says that's her weapon that was missing. There was another projectile there that was too deformed or damaged to be analyzed. Mr. Jones couldn't tell you what kind of weapon it came from. Miss Jackson makes a big deal out of her cell phone. She doesn't have her cell phone taken. Don't know when she got her cell phone back. It was extracted. No information from her cell phone that she said was there. No activity was provided for, or lack of activity from the time she said she didn't have it. There's nothing putting Mr. Westbrook's there except her testimony. The detective talked to a guy named Mike Smith. Mike turned out to be a name for the one that's in the investigation. He was ruled out. There was another Mike Pelican. He recognized the name, but he couldn't tell you how to follow up with that one. Other names just mentioned, didn't hear any more about it. Listen carefully, if you will, to the 911 call. This, at least the second half. It's about four and a half minutes. And you hear, I think it's Mr. Johnson. Tell me what you hear. Tell me if you hear a name. You hear some noises, some grunts, you hear. The witnesses said, I'm dying, I've had it, I'm gone. Listen and see if you hear a name. When they say, who shot you? Who shot you? The state wants you to take a leap with it. And if Mr. Smith goes around and say they have brought you some evidence. Was he there? Was he involved in this? I don't know, I wasn't there. Is there reasonable doubt? Yes, of course there's reasonable doubt. You can take this stretch with him and find him guilty if you feel like it, but you took an oath that if you had reasonable doubt, the 12 of you, 12 different people, 12 different verdicts, that you'd find him not guilty. If he was there and did it, he's guilty. If he wasn't, he wasn't. If you can't decide after deliberating, and you don't know, and you have questions, that's reasonable doubt. Thank you.
Thank you, Mr. Vasquez. Mr. Smith?
Mr. Vasquez doesn't want you to believe Shirley Jackson. You can't believe Shirley, because she's part of this. That's what he's trying to tell you. She looked like she was part of this. She's dating a guy. She's got 5 kids. She's trying to make a living. She has a job. So she's hanging out with him and his family on Easter. She's letting the men talk on the porch while she sits in the car, watches her kids play in the yard with the other kids. Plays on her phone. She's not really liked by Mr. Westbrook's family. She's ostracized, but she's there with her man, being a supportive girlfriend. Takes him where he wants to go. He goes with them, they put the kids down, then they go back. Late at night. She's on her phone. And what does he do? He comes and takes her phone from her, brings it in the house. What's up with that? Why didn't you say something? That's a red flag. Well, cause a fight, I want to argue. You know it's going to stir something up. It's going to be a all-night argument. But she just goes along. We need you to take us down the road. Where are we going? We'll just tell you where to go. Well, they act like that makes her an accessory. I'd be willing to bet she takes him and his cousin and his buddies wherever they want to go, whenever they want to go, because she's got a ride. And he doesn't. Doesn't make her an accessory. Doesn't make her a party to the offense. She's not an accomplice because she doesn't aid, solicit, or encourage them to commit the offense. She didn't even know they were taking the gun until he grabs it on the way out of the vehicle. He would know where she keeps her gun. And if he knows he needs it, he's not going to say, give me your gun. He's just going to grab it on the way out. That makes sense. That fits with what we know. When they get out, stay here. I'm not going to just stay here. Just stay close. She doesn't like that neighborhood. She doesn't know that neighborhood. But she knows just a couple of minutes away, her stepdad has a house. He's not there. I can just go park there and wait. But she knows at the end of the day, at the end of the night, whatever they're doing, they're not up to good at this point. But she doesn't know what they're doing. So how can she be a party to the offense? She goes, and she leaves there after a while, and she goes to Fuzzy's, and she gets a drink. She goes from there, and she's just riding in the neighborhood. And that's confirmed by the video. Because we see her right before the police pull up, just riding through the neighborhood. If she was a party, do you think she would have gone right back by that house? She's riding the streets, waiting on these guys to come back.
She's not an accomplice. She's not a party. But what does she tell us? 3 men got out. Robin, Dijon, and Paul. That makes sense. They had been together all day. Paul and Robin are cousins. That makes sense. Easter, family, get together, barbecue. Dijon, buddy. They're going to be there. 2 men got back in that vehicle. And how do we know that? Because Shirley told us. We know which 2 men got back in. Paul and Dijon. We also know that Robin did not get back in. He took a different ride that night. He took a ride in an ambulance. But I suspect he was gone before he ever made it to the ambulance. She said that. She told you that. But who else saw that? Ray. Ray Mason saw it. As he's hiding underneath the porch, he tells you, 2 men left that house, went down the railroad tracks, and got in that same car. And why would he have that car flagged in his memory? Because when he got back at 11 something, and he's out smoking, that same car came right down Elgin, the dead end of Elgin. 4 houses on that little dead end. But instead of just doing the normal thing and whipping right into that last driveway, backing out one time and going straight back out Elgin, it took, and you can watch it on the video, it takes them about 45 seconds to do that awkward 17-point turn to get out. And we know that is corroborated by the video, by what Ray said, and by what she said. Nothing she said has been discounted in any way. Now she was a little dishonest at first. They caught her at work. But why? She told you from the stand. Why was she dishonest at first with the police? Because her kids, her whole world was with his family right then. As soon as she got those kids back and they were safe, that's when she went on her own volition to the police, and she told the truth about everything. She told them who, she told them what, she told them where, she told them why. She told them how. And everything that she said checked out. Where she was at, where she went, what she bought when she went into Fuzzy's. She was just riding through the neighborhood, and she's making that loop. She catches that loop. The police have already been called. But right after she makes that, she comes back around, and she's picked them up. And where does she go? She takes them back, she drops Dijon Ivory off, then she goes to her house. What makes it real to me, what makes it very apparent that she is not a party to this offense, is that she's human. When they get back in the car, she says, "Where's Rover? Where's Fawn?" Well, he got shot. What? He got shot. The dude shot him, so I shot the dude. Well, let's go get him some help. No, we gotta go. When they drop Dijon off, they go home. What happens then is telling. He's just told her, my cousin, my flesh and blood is dead. And I shot that dude. And I killed him. And what does he do? He goes to sleep. Sleeps like he doesn't have a care in the world. What does she do? She didn't see any of that. She didn't witness any of the threats, the violence, the gunslinging. She can't sleep that whole night. She just watched him sleep. That's human. When she goes to the police, she tells them where the guns were, exactly what she wrapped them in, what dumpster she put them in. That was corroborated. We found them right where she said they would be. Told them where the magazines were. They weren't able to find the magazines, but we did find the guns. She told them where she drove before, during, and after the robbery. She wasn't at the robbery. She dropped them off, not at the front of the house, but down the railroad tracks. She went to Fuzzy's. She went to her stepfather. She went to Fuzzy's. She drove back through the neighborhood until she heard all Westbrooks come holler. Now, what was different about that? Well, he's changed his appearance. Why would somebody change their appearance? Why would he take your jacket off and just be wearing a shirt and leave your jacket on the railroad tracks? But he went back and he got that after she said, go get your jacket. What's wrong with you? So he gets in and then Dijon gets in, which makes sense because Ray says one of them went back to check to see if that white dude had come back. So he would be later getting to the vehicle than Mr. Westbrook's. She told you about that weird turn where they wouldn't just let her turn into the driveway, which instead of not gaining attention, really did attract that attention. That's corroborated. You can look in the videos. It takes about 45 seconds to go that 4 houses and turn around and come back out, whereas it should have taken probably 10 seconds. Think about that 911 call. Think about if you're Robin Buckingham. You have just witnessed the murder of one of your only friends, the one friend who is helping you out when you're out of doors, giving you a place to stay. Traumatized, had gun pointed to her, pulled out of the shower basically, naked in a room with strangers, with people she knew, threatened to within an inch of her life, had a gun pointed at her head. Don't move, don't put your head up. They waited. Instead of just taking and going, they could have just taken the whole damn safe. But they waited for Ahmad to come home. She's on 911, having to watch what she says because there's a gun pointed at her face as she's talking to 911. And the dispatcher is asking her, why can't you tell me what he looks like, where he's at, what's going on? I can't. I mean, listen to it. The despair, the trauma in her voice. They all had guns. They used violence. They went into the one place a man should feel safe in this whole world, in your own house. When the whole world is against you, you can go home. You can turn on the TV. You can pet the dog. You can lock all that other crap out. And you can just be yourself. Until 3 men barge in, point guns at your face, take everything that you've worked hard for, and then threaten your friends. That was when it turned violent. That was when it turned violent. When he threatened, if you don't give me what I'm looking for, I am gonna shoot one of these girls. Only then did Ahmaud Hayden get up and struggle. He shot Rowan Dotson. Paul Westbrook shot him. Dotson didn't shoot him. How do we know that? Because Dotson went down, almost fell on Robin. He was found at the foot of the bed. Ahmaud Hayden was found in the doorway. And where was Ahmaud Hayden shot? In the back. He wasn't going towards Paul Westbrook's. He was trying to get out. He was shot in the back. And he died as soon as he was shot. Because it punctured his aorta. This was a traumatic event. The three men acted together. They're each guilty of the murder of Ahmaud Hayden, but they're also guilty of the murder of Rowan Dotson. Because had they not gone into somebody else's house with guns to commit robbery, to get an easy lick, neither one of those men would be dead. It's a very simple case. The facts of this are simple. Even if Westbrooks, who did, I believe, shoot him, hadn't done it, if one of the other two guys had shot him, he would still be just as guilty because they were acting together. Equally guilty under the law. We talked about this in the right. Nobody here had a problem with that if those were the facts. That's the third way to commit murder. To commit an act clearly dangerous to human life. And we talked about the different examples about how you can do that. And each one is just as guilty of the murder for that. There is no reasonable doubt that he is guilty as a party, if not the sole actor in this case. Because of that, justice demands that all of you are unanimous in finding that he is guilty of this offense. That's what I'm asking you for. That's what I'm hoping that we get. And again, I want to thank you one last time for your service in the jury.
Thank you, Mr. Smith. Mr. Vasquez. All right, ladies and gentlemen, you've heard the court's charge and closing argument by the attorneys. I'm going to hand the charge. Let the record reflect state's attorneys present, defendant, and defense counsel are present. I have received a message that the jury's reached a verdict. You can bring the jury in, please. All right, let the record reflect that the jury's seated, state's attorneys present, defendant and defense counsel are present, and I would ask the fourth person, has the jury reached a verdict? And is it the unanimous decision of all the members of the jury? Thank you, sir. You can hand it to the bailiff. Mr. Westbrook, if you'll please rise. We, the jury, find the defendant, Paul Edward Westbrooks Jr., a.k.a. Paul Edward Westbrooks, and Paul Westbrooks Jr., guilty of murder as charged in the indictment. You can have a seat. Does either party wish to have the jury polled?
No, Judge.
Mr. Vasquez?
No, Your Honor, as long as they said it was unanimous.
Thank you, sir. All right, so what that means, ladies and gentlemen, is that at this time, the first phase of the trial is over, and we'll move into the punishment phase. Mr. Smith and Mr. Vasquez, why don't y'all come up for a second? Let's just see logistically if it's kind of late in the day. Yeah, I just signed it. We need to do that. We need to do the charge. So let's just do that. Okay. So at this time, what we're going to do, we have, there's another charge. The lawyers will be able to put on any other evidence. And so instead of us trying to squeeze things in or go late this afternoon, we're going to go ahead and take our evening break. And we will get started tomorrow morning at 9 o'clock with the punishment phase of the trial. Mr. Smith and Mr. Vasquez, is there any objection to us releasing the alternate since we're at this point?
No objection from the state.
No objection, Your Honor.
So we want to thank you very much. You do not have to come back tomorrow now that we've received a verdict. There would not be a time for you to step in. And so we appreciate you. If you need anything for your employer, you can ask the bailiff this afternoon where to get that. For the rest of you, you are still under those same admonishments and instructions that you were previously given. So please keep all of that in mind. Get here a little before 9 and we'll do our best to get started right at 9 o'clock tomorrow morning. All right, have a great evening. You're all excused. I have to do that tomorrow morning. Yeah, I'm gonna do that, but the other I'm supposed to do in front. All right, let the record reflect the jury's outside the presence of the courtroom. At this time, I will revoke any bond amount that is set on the case, and there will be no bond on the case. Also, I'm making myself a note tomorrow before we get started and read any enhancements to accept the verdict formally. I don't know that I actually said the word, so I'll make sure and get that done before we get started in the morning. I have signed the order. Mr. Smith has filed a motion for fingerprints to take Mr. Westbrook's fingerprints. Mr. Westbrook, you need to let them take your fingerprints this afternoon. Get that done before you leave. Anything else we need to take up before we leave?
I don't think so, Judge.
I have emailed you both a proposed charge. So take a look at all three of you, take a look at that. If I can ask you all please to get here at 8:30 in the morning so we can make sure we have the charge done correctly. If you have any issues with it, we're in a group, shoot a text or an email. Probably a text would be better if it's after hours, just so I can be prepared for anything. I think it's okay, but 8:30, 8:45 at the latest for us to get that all good, okay?